Good afternoon, everybody. My name is Trisha Ravenhorst, and I'm coming to you from South Carolina today. I'm with the South Carolina Coalition Against Domestic Violence and Sexual Assault. And this is one of my absolute favorite topics that we do at the Family Law Community of Practice. So if this is your first time joining us for a talk about creative civil protection orders for immigrant survivors, you're in for a treat, and hopefully it will stretch your thinking as you do this important work on a day-to-day basis in family court. So with that, I'm joined here today really by the rock stars in the room, which is Rosemary Collins, family court judge coming to us from Illinois, and Leslie Orloff, of course, our fearless leader. And just a reminder that this is a grant-funded presentation, and these opinions are our own, but we encourage you guys to join us in expressing your thoughts and concerns. And before I pitch this over to Judge Collins to really get us started here today, he's going to tell us a little bit about herself. When learning more about her, my favorite thing I learned about her online is that she received an award a few years ago, and the headline was "A Warrior for Victims," and that is exactly who she is. So on that, Judge Collins, I'll pitch it to you to tell us a little bit more about yourself, and then let you and Leslie take it from there.
Well, thank you very much. It's really my honor to be here. I'm a retired circuit court judge from Northern Illinois. I live north and west of the Chicago area. I was on the bench for about 30 years. During that time, I was the presiding judge of our family division and the presiding judge of our domestic violence division. And in the domestic violence division, we combined both the criminal and civil cases together so that we could provide a coordinated approach for survivors and their families in the area of domestic violence. So they didn't have to try to run around from one place to another. My passion has always been to work with survivors. I started as an advocate in law school. I was with the prosecutor's office when I first got out of law school, and then I went with the public defender's office, and then I went on the bench. So I've worked with Leslie Orloff for many, many years now with immigration law. I was the certifier for our district. So I've done a lot of U visas and a lot of training in that area. So I'm really honored to be here. Leslie, are you on?
I'm here.
There she is.
Here I am.
Mhm.
So I'm happy to be here too. Protection orders are near and dear to my heart. And as somebody who, I was representing immigrant victims in protection order proceedings starting in 1983, and spent a huge part of my 17-year litigation career doing protection orders solely for immigrant survivors. And so why I get excited about this presentation and this work is this is how, long before there was immigration relief, bringing cases in family court, particularly protection orders, getting custody within protection orders, getting economic relief, and all kinds of other things within protection orders was how we protected immigrant victims back in the 80s. And I would argue that in any time of increased immigration enforcement, it is a tool we have. And I'm proud to say that judges throughout the country have been trained by judges like Judge Collins to know a lot more about the roles they can play in these cases, and we just need to ask them. So I'm excited about talking about what we're here to discuss today and helping you all strengthen your work with immigrant survivors and the kinds of things you request judges to do in protection order cases. And now I have to change slides, right? That's my job. So we're going to start off very briefly. I want to talk about, we did a piece of research back in 2012, where we actually around 2012, where we looked at when and if immigrant victims would be willing to seek protection orders. And what we found is that despite the fact that almost 61% of them knocked on the door of a victim services or went to a legal services agency for help with domestic violence, when they went, they had no idea what protection order was, that there was such a thing. They didn't knock on your door saying, I want a protection order. And what we found is that with a good advocate or attorney support and safety planning, 81% of immigrant survivors were willing to get protection orders, particularly when they were experiencing high levels of abuse. And this research, this was the early days of safety planning. And you could see the impact that we as victim advocates and attorneys were having on our clients' willingness to step forward and get protection orders. 96% of the victims, immigrant victims, found them helpful. And many of those protection orders were issued, including orders to the perpetrator not to interfere with the victim's immigration case, not to turn the victim in for removal, et cetera, et cetera. And what we found is that although violence went down after they got protection orders, immigration-related abuse was a big part of what the violations were. And we'll be talking about this research again later when we talk about full unlawful contact protection, no unlawful contact protection orders. All immigrants, everybody is eligible for a protection order without regard to the immigration status of the victim or the perpetrator. The issuance of a protection order has no effect on anybody's immigration status. There is jurisdiction, meaning all persons are eligible to receive protection orders regardless of the immigration status of any party or a child. And victims and their children, as we're going to be talking about today, often need creative remedies using the state's catch-all provisions, which all states have that flexibility. So the first poll we have, and then I'm going to turn this over to Trish. Is it true or false? Christopher, can you share the poll, please? Hopefully, yeah. True or false? Violation of a protection order is a deportable offense. Wait and see a few more. Give you a few more seconds to participate. Almost at 60%. A few more people want to join. Okay, great. So, are we sharing the results? I think we are. 85% of you say true. 15% of you say false. Trish, what's the answer?
It is true. So this is an important thing to remember as you're working through that. And you guys can, I can do the next slide. Okay, I forgot I'm in trouble.
Oops, now we did too.
Oh,
there we go.
okay, great. Yeah. So in all the, there's a long list of things that, are, can subject somebody to deportation. I think people are surprised that the violation of a protective order itself is a deportable offense. What's unique about this ground of deportability is that it's not just it's not a conviction. A criminal conviction is not required, but simply a civil finding of a violation of a protective order can result in the loss of permanent residency status and the deportation of the individual who's found to be in violation. So, of course, it's really, really important, when going into protective order hearings, that we work really, really hard to ensure that the victim is not the subject of a protective order. And of course, if the victim is subject, is subject to a protective order, that they are well advised to make sure that they are not placing themselves in any situation or being manipulated by their abuser, where they would be at risk for being found in either civil or criminal violation of that protective order. So for those reasons, it's very, very important to go into a family court hearing or a protective order hearing with your antennas up and making sure that we're really pushing back on any effort by the abuser to have a protective order entered against a victim. Okay, so here's our next poll. So based on that, which of the following is a deportable offense? So check all that apply. The first is domestic violence as a criminal conviction, finding in a custody case that a protective order was violated by further abuse of the victim, criminal conviction for violating a protection order, or agreeing to diversion in a protective order enforcement case where upon violation, diversion turns into a conviction. So you guys want to answer that poll? I can't see the results, Leslie, so.
Yeah, and I had a screen thing that happened weird, so I don't know what's going on.
Oh, here we go. Great. You guys were answering it while I was reading it. Good job. Yeah, so the answer to this question is that all of the above apply. So, of course, a domestic violence criminal conviction is a little bit more obvious. The second answer, finding in a custody case, was what I was discussing earlier. So, even a civil, a civil contempt finding or a civil finding about a protective order in the family court can result in a deportable offense. Of course, the criminal conviction there. And then Leslie, I don't know if you want to talk a little bit more on the last one, just the nuance about the diversionary situation. Obviously, each state law has sort of different diversionary program requirements, but.
Yeah, so I can do that. By the way, my whole computer just went weird. So I'm going to have my student try to figure out, I might have to rejoin, but anyway. So yeah, so diversion, what happens is under immigration law, for purposes of immigration law, it is if you admit to something, so diversion usually requires that you have to admit a facts that if you then violate the order in the future are automatically used against you. And that admission means that it's considered a crime under immigration law for purposes of deportability. And so that's the problem with those cases.
Thank you, Leslie. So now we have a new poll. So if you can launch this poll, Chris. So what are the dangers of issuing a protective order against a victim? Again, this is also check any that apply. Endangers victims and children's safety, increases coercive control, perpetrator could win custody of the children. Immigrant victims, are one step away from deportation. Of course, you guys have other ideas. Please go ahead and type that in the chat.
I'm trying to get.
Yeah, whenever you guys think to close the poll, let me know. Great. And then somebody monitoring the chat, let me know. But yeah, so again, this is also, all of these apply. So, I think having protective orders really places, one, as we know, it very much sort of confuses sort of the view of the victim. So I think that, having a protective order against a victim can really change the dynamics about how a victim is viewed, how they're able to keep their children safe and navigating. Of course, when an abuser is successful in getting an order of protection against a victim, then that's obviously a huge increases the ability to abusive litigation tactics and coercive control. Both in the criminal and civil contexts. We know that when an order of protection is entered against a victim, it is just much more difficult for them to sort of advocate for themselves and may lose custody of their children because they're now seen in a more negative light. And as we discussed, this huge risk is we know that survivors who are in complex relationships with abusers, especially when they have children in common, having an order of protection, being subject to an order of protection is a super high risk situation for them because, again, every day is different and every day poses a risk that some incident's going to happen where they're the ones that are perceived to be the primary aggressor on that particular day. So I think we have to really, really stand our guard in the protective order hearings to make sure that victims are not being subject to these in any way, shape, or form.
And this is an area where we can provide technical assistance. Like if you've got a case that might end up with the victim considering issuance against them. I used to litigate these like murder trials. I would do anything we could do to prevent issuance of a protection order against my immigrant clients. And there's some creative ways of settling cases that, you might both agree to dismiss without prejudice. I have done that. And then just wait for the next incident when, unfortunately the victim is hurt again, and then go back in to get a protection order when he can't because he's already dismissed with prejudice the charges against her. So you really want to think about creative ways to do that, and we can be supportive of you in those cases.
Yeah. And just anecdotally, for me, it's certainly come up, when, if the client I'm representing, we're the petitioning party for the order of protection, but for whatever reason, the court is sort of, doesn't really know what to think. And so there's a lot of pressure, at least here in South Carolina, to sort of the judge may from the bench say like, well, would you guys agree to entry of a mutual order of protection? And so I think I really had to prepare my clients for that. Like, in South Carolina, like the petitioner actually has to agree to that. The court can't just do that. So it's like really making sure that you're slowing down the proceedings, taking the time to pause and make sure your client knows what agreeing to a mutual is. And deciding. I've had to really have some tough conversations with clients about, do they want this bad enough to, if the judge is saying we're doing a mutual or nothing, making sure that's a real active choice for the survivor, because having an order of protection entered against an immigrant survivor, the consequences are much more serious than for a citizen survivor. So, I've had clients like think that nothing is better than something. So it's, just making sure that you're prepared to push against that and make sure your client is fully
And
informed.
Judge Collins, if you're going to litigate it, why don't you tell us what the approach?
Yeah, well, I think it's important to distinguish between self-defense and primary aggressor determination. So first you want to look at self-defense. If there's self-defense there, then that kind of leads you where you're going to go on this. So look at, did the victim commit an offense? Were they acting in self-defense? And then go, if they're acting in self-defense, that really kind of, you can stop there. But if not, then you have to look at who's the primary aggressor in the relationship. And then you can look at what's happened before in the relationship. Look at the facts and circumstances surrounding not only this case, but other cases. Like, for example, if a guy puts down his ring on the table, as we saw in one of our training videos, he puts down a ring on a table. Well, to her, that means he's going to beat her up, because the last time he did it, he hit her with a ring and it left a mark. And so that got him in trouble. So now he takes his ring off before he
Collins,
hits.
you're breaking up. I wonder if you put your...
What? Yeah. Can you hear me now?
You're breaking up. We're having
For me, it's not breaking up. I can hear fine.
Okay.
I think she's
So
frozen.
it's important to litigate these things, because particularly with an immigrant victim, the consequences of that victim getting an order of protection placed against them are very, very strong. So make sure you do that. Be sure you issue a Padilla advisals in protection order cases. Tell your client what the consequences are. Make sure the judge tells the client what the consequences are. Make sure you strengthen your enforceability to make sure that you know what they understand and what is happening. And get the protection order translated if you can, even if your client speaks English, but as a different, or as a second language. They may not understand the nuances and some of the language used there. So even if you know that you can communicate them in a way, make sure you get it translated so they can have it two different ways if possible. And if they don't speak English, then obviously you must get it translated so that they can understand. Because if they don't understand the consequences or what they're ordered to do, then they're going to have trouble in the future that could affect their ability to stay in the country. It should be the court that translates the order, but not all courts will do that. So, yes, it should be the court that does it.
Great. So we're going to launch into now a discussion of creative protection orders. And as we start, what's really important to understand is that we've done surveys of all state protection orders over the years. And every state, one way or another, has a catch-all provision that, when you look at the case law over time, is very clear that judges have the power to issue anything that, in an order that once they found domestic violence exists, or once they've found it from the uncontested affidavit from the victim, it doesn't have to be a trial, it could be from the affidavit underneath, then they can order anything that could curb future abuse, stop harassment, interfere with the power and control and the coercive control going on in the relationship, offer the victim a remedy to passive use, better protect them in the future, to help them overcome victimization. There just needs to be some nexus with victimization. And it's really an opportunity for courts to counter immigration-related abuse and offer culturally helpful remedies.
So let's talk about one of those creative remedies. Have you ever issued a order for a victim who was continuing to live with their abuser? Can you raise your hand if you have?
Or obtained one.
Or yeah,
If
obtained
you
one.
got an order for somebody continuing to live with your abuser. So
Right.
the
Or
hand raise
work
is,
with victims who obtained one and then returned to live with their abuser. So put your hand up if you've ever had either of those things. Obtaining a CPO for a victim who was continuing to live with the abuser, or worked with victims who obtained a CPO and then returned to live with their abuser.
so we're seeing
Oh,
some hands,
I
Judge.
see some. Yeah, I can't see all of them. So, but I do see some, and the ones that I can't see, they all have raised their hand. So this is a common problem throughout the court system. I mean, it happens a lot. So why might victims not separating from their abusers seek a protection order? Why might you be talking to a victim and they say no, they don't want an order of protection? Um,
Christopher?
so the poll is up. So if you could check all that apply.
A couple people responding. 40%. Let's have a few more join. Okay. So here are the results, Judge.
Yeah, we see that, in the curb abuse one, which is one of the lower numbers. I do see survivors oftentimes that say, if I get this, he will hurt me. And so they are thinking they will have less abuse if they actually get an order of protection. Um, so we know that that doesn't always work, but they also know their offender, and they know if they go and bring this public, they could get some ramification about that. So it's a very tricky situation for survivors.
But basically all of these, I mean, people get them because they live in extended families. People might get them because there's limited housing options of where the victim or the perpetrator might go if he's ordered out of the house. For immigrant survivors, 90% of you got this. The biggest issue, the reason this has been a major part of my practice for my entire life, is because immigrant victims have to wait, some of them up to almost 2.9 years, almost 3 years before they get work authorization when they file for VAWA, T, or U, or SIJ. Some come faster, but that period of time, these full contact protection orders, no unlawful contact protection orders, are really life-saving and very helpful to victims.
We did some work in Hawaii. In Hawaii, it was very hard for survivors to get protection orders because there's no place for people to go. Housing is really difficult. It's very expensive. Generations of families often live together in housing. So the no contact, no unlawful contact order protection was often the only way that survivors could actually get an order of protection. So the no state's protection order requires separation of the victims, not one state. So if your judge doesn't know that, just gently refresh their recollection of the statute, because it does not require separation of the party. It's not done in every jurisdiction, so it may be not the custom and practice, but it doesn't require that they live separately. You can put in there that there's no abuse, that there's no immigration related abuse, and that's really important for our immigrant survivors, and no unlawful contact. And you can put in a lot of jurisdictions that the batterer gets treatment. And that's an important thing. If they're going to be living together, it's really important that somebody else is working with this abuser to make sure that they sort of at least understand the consequences of their behavior and perhaps try to change their behavior.
So these orders can be super helpful. I've had lots of clients, I mean, hundreds of cases of getting these. And in fact, so how these no unlawful, whoops, did I skip? Wait, hold on. Did I go too far? Okay.
Yes, you go.
Okay, so I'm in the right place. Okay. And so research basically among immigrant victims has found, and this is a piece of research we did, and we looked at, do they work? Like what kind of protection do these no unlawful contact protection orders offer victims? And what we found was with immigrant victims who were getting these, like a huge percentage, like 80 or 90% of them saw reductions in the amount of violence they were experiencing. And years ago, we had a peer group of survivors, of Latina survivors, and I remember the story so well because one of my clients had her protection order on her, and somebody asked her about protection orders, and she basically said, ever since I got this piece of paper, he raises his hand against me because they were still living together, and I raise my piece of paper, piece of paper, and he doesn't hit me. And that for them, for the way the survivors describe it, is it creates a change in power in the relationship that gets them to the point where they can begin thinking about how they might separate or where they might go. But it really, really helps reduce violence together with safety planning for victims who don't have work authorization yet. And in fact, that and the other thing is that what I saw in my cases and what those of us that have been doing these nationally for years see is when my client in the future she has a no unlawful contact protection order, she's still living with the abuser. Almost all of my cases ended up with those orders because the victim came in an emergency protection order, was gonna leave. By the time she served the perpetrator and got back to court for the full order, she wanted to drop it. And I convinced her that, and I would say, why do you want to drop it? He's promising not to hit me anymore. Okay, why don't we have him make that promise to the judge? And that's how we got most of my no unlawful contact protection orders. And the first case, and what happened was that in my cases, when those clients called the police in the future for a future incident of violence, domestic violence, physical assault, something like that, the police took it much more seriously than if they didn't have that piece of paper, that protection order issued before. So they don't usually enforce them for separate, that he kick him out of my house. They're enforcing them because another incident of violence has occurred and the police react more strongly. Just so you know, the first case to go to the Supreme Court in 1993, U.S. v. Dixon, it went on double jeopardy because I had convicted an abuser of 4 counts of violating the protection order and sent him for criminal contempt for 600 and some odd days to jail. All those 19 protection orders that he violated were no unlawful contact protection orders. And the Supreme Court found them valid and, allowed the U.S. attorney to go forward on the assault with deadly weapon case. And I got convictions for violation of the protection orders.
So what are your options when a victim comes in and wants to drop a protection order? There are several. What you have to do is...
Sorry, there you are.
There you go. There are several you can do. One thing I did always is I asked for identification, not because I'm trying to put somebody on stop, but I've had imposters come in. Offenders will come in with their new girlfriend who will say, I am, Judy Jones or whatever, and I want to drop this order of protection. And they're not actually Judy Jones. And so I always check the identification to make sure it is the person named in the order of protection. And then I would always ask them why they wish to drop the order of protection. I'd ask them if they would talk to an advocate. I was fortunate. I had advocates and domestic violence assistance officers available. And so I could call them and say, come up here and talk to somebody to make sure they're doing it freely and voluntarily. And when you find out the reasons, it's often because they need help in the home. They need more financial assistance. They need somebody to babysit. So you can often go to the no unlawful contact, and they will agree to that because they really want the abuse to stop, but they might need them to be in the home. So when they go to work their shift job, they have somebody in the home to take care of the kids. So it's often a really good alternative for people who are wanting to dismiss or revoke their order protection, but still need protection.
Trisha?
Yeah, so I think that, as a practitioner, I think my question is really, and I think admittedly when we were preparing for this, like I'm sort of playing the role of like I live in a state where is really not done. I think, sort of on the front end going into court and sort of on the back end, like, once people reconcile, it's like, hard to, if they do reconcile, like it's hard to get these contempt issues enforced. So I think like, as we're pushing the envelope on encouraging the no unlawful contact stuff, like what are like some good practice tips to sort of, so maybe Leslie, like, Judge Collins spoke about it from the bench, but from, talking to your client about why they would want to still continue with the protective order hearing, even if there is a reconciliation or a decision to go back into the home. Like, how does that conversation go?
My clients, when I did it, it was really, what I would say to them is, as I said, if he's making the promise to you, let him make the promise to the judge. And also talking to them about enforcement. Like many of them, particularly immigrant victims, may have called the police in the past and got really bad responses or service or something like this, and came to court as a way to have some control over the process and try to reduce the violence. And explaining that, they can live together. It doesn't mandate that they be separated. And that if you have one of these orders and you call the police for help in a future violent situation, the likelihood that the police are going to take it seriously is higher. And that's one of the things that I would use to talk to my clients about it.
Yeah. And then of course, like my next kind of practical question and to both of you is really looking at, if for those of us who are practicing in states where this is not done, would be very unusual, push the envelope, sort of what is sort of the most effective and simple argument, besides like reading the statute. Like, I mean, I was encouraged, like, reading the statute and thinking about that and sort of fighting against like practice and norms versus what's actually allowed in the statutes. I didn't know what kind of success you've had in terms of speaking to the judge, placing things on the record, and then, of course, we in South Carolina are looking for opportunities to appeal when there's an incorrect, interpretation of law.
Well, I think judges often respond to the argument that this really reduces the amount of cases they have in court. And so it's kind of like when police started arresting people, they didn't go back to the same house over and over again, 3 or 4 times a night. This reduces the time that these people will be back in front of you because you still have the order protection. So if there's a violation, they call the police. Whereas if they don't have the order protection, then they have to go through the whole process again, get another order protection, and come back in for another couple of hearings. So it really reduces the amount of time that the judge will have to spend on the case, which is always an appealing argument for judges. But it also increases the safety and also compliance with your orders. Because if I order somebody to go to a batter's treatment, and if I still have the order protection there, if they don't go, then I can do something about it. And it also makes sure that they will go, because you can use that also as an incentive, saying, I know that you want to drop it. I had a survivor one time say, he's in classes now. That's all I wanted. So I don't need the order protection. I said, well, let's wait till he gets through those classes. And you can come back then. And if you want to drop it, then we can do that. And so, I said, if you drop it now and he stops classes tomorrow, what are we going to do? And so that's a good way to, I think, convince judges that this order is really in the best interest of not only the survivors and their families, but also of the court.
Yeah.
And to respond to Jana's question about when you have an abuser at risk of deportation, I think that's where your relationship between you and your client is important in terms of how you work with your client. If you have a client who's concerned that if she calls the police, her perpetrator will ultimately be deported, one of the things about a protection order, as opposed to a criminal case, is the victim's in control. So she could, you can work with your client to figure out like when she's going to enforce an order, and if she's going to enforce an order, and how she's going to enforce the order if ongoing violence is occurring. So she could choose to come to you if she's concerned, and you can talk with her. You might decide to do some kind of a civil contempt. I mean, there's a lot of different ways you could think about it. but that, and then the other thing is I found with this issue about economic support, my first question to my client is, are you talking about a potential future possibility of economic support that you're not currently receiving now? And then I would talk to them about VAWA and T and U and how they may qualify for work authorization themselves if they file one of these immigration cases, because it's really important separating the hope of money coming someday from what's really actually happening. So is he really supporting the family now, or is he drinking the money? And getting into those kinds of things before the economic support argument ever worked with me in terms of my clients. I would really take it apart and weigh whether that was, how much that was really the issue.
Yeah. Well, thank you.
Okay.
So I think the next question, Judge Collins, is sort of really looking at sort of the broader folks around the no unlawful contact, but looking at what are some other issues that need to be addressed in protective order hearings to make sure they're more effective.
Well, this just goes right with what Leslie was just saying. And we should all be so lucky to have attorneys like Leslie who think about the economic issues, because that's really one of the number one reasons that survivors can't can't go on by themselves, is they can't do it physically. They don't have a place to live, maybe they don't have food to put on the table, they can't pay for medical for their children, and they need economic support. So I think, but some other survivors may not. So it's really important to talk to your survivor and find out what are their needs that they need addressed. I mean, is safety the primary concern? You know, what about who's going to take care of the kids, or if you're going to exchange the children, how are you going to do that in a safe manner? Where's everybody going to live? How can you do it? But financial support to me is huge. You know, they need their phones. They need the ability to pay for their phones. They may need fares to get on the buses. They may, you know, there's all sorts of financial issues that could really impact their ability to keep themselves safe. And you also have to look at their cultural, religious, and community support needs. You know, what church do they go to? Do they still want to go to church? Do they want their abuser to go to a different service or a different church? You know, how can you address that? And make sure they have access to all their personal property and documents, particularly in immigration cases. The immigration documents can often be held by an abuser as a method of control. So make sure those documents are turned over, their passports, their children passports, any kind of papers that they need, birth certificates, anything that they need, they should have. And you can address that in an order of protection. So, nope, I am trying to do these slides. There we go. So take time to address the victim's need. And you can only do that with conversations through them or conversations through the attorneys. But we know that most of the times that people seeking an order of protection are not represented by an attorney. So talk to them about, you know, things they may not have thought about in the moment, because they're just dealing with the abuse. They're dealing with the trauma of leaving. But ask them, you know, what's going to happen in this? What are you going to do about school? You know, what about school activities? Are there basketball games or baseball games that, you know, they're both going to be at? How will we do that? Talk about their cultural issues that they may have or expectations they have, how their family traditions are handled, who has a birthday, who has a graduation. Talk about all the other issues that are important to a family in their everyday life that they may not be thinking of them at that time. And make sure that you understand that you have broad discretion to grant additional protections based on all the evidence. So you don't have to be bound by a single narrow way of doing things in an order of protection. You have broad discretion to make them as available and make justice available to the parties as you can by your catch-all remedies.
So you, as lawyers, you should be asking judges for these kinds of remedies.
Yeah.
Judge Collins, can you share an example of some remedies that you've used or your colleagues have that address religious or cultural needs?
I can. I've had actually services that they want to cleanse their home, and I've also had requests that they not go to a petitioner or a practitioner of a certain religion to put a hex on them, because that was actually threatened by the abuser, that they would go to the high priest or priestess and get a hex put on them. And that was very important to them, that that didn't happen. So you can do that. I also had a case, this isn't really religious or cultural, but I know of a case that had two bus drivers that were involved in a domestic violence situation, and he beat her up pretty bad. She had to go to the hospital. She lost a lot of time because of her sick time and her vacation time. So when it came to the actual hearing, what she really wanted more than anything, money was great to pay the bills, but what she really needed was her time, because she couldn't take off to go take the kids to anything. She couldn't take any sick days. So the bus district, the school district, agreed to transfer his time to her account. So she got her time back. And that was the most important remedy to her, because that took the pressure off who's going to take the kids to the doctor and things like that. So, but you can't find that out unless you talk to your survivors to find out what is the most important issue for them. And then they'll tell you and you can address it.
Right. And so why is it best practice for judges to address custody and visitation routinely as part of protection orders?
Well, it's really important because, again, these are the issues that everybody has in their life, and it won't go away just because you issue an order of protection unless you deal with it in the order of protection. So you have to say, you're going to see these children. How is that going to happen? How are we going to do it? Do we need to look at our supervised visitation? Do we need have visitation exchange? Is there another party that can affect these situation or these custodial exchanges from one party to the next? But you have to look at that, and you have to go into it in great details to find out what's important to people, and how you can address that. So you can address all those things to talk about what's important to them, vacation time, birthdays, graduations, all those things. And you can make sure if you work it out ahead of time, yes, it takes a little bit of time, but you're going to spend that time on this case one way or the other. And so if you do it at the beginning, it helps people comply with the orders, it helps keeps families safe, and it avoids them having to come back to court again.
So is the judge going to get mad at me or think I'm asking for too much detail if I ask for these kinds of details in visitation orders and protection order cases?
Well, if nobody's been doing it, then the first time they're going to, maybe look at you twice. Or if they have a courtroom full of 50 people, which I've had waiting for orders of protection, they might. But that's why it's important to be prepared. So if you talk to your client ahead of time and say, these are the issues I'm going to bring up. But if it's like, well, we might want some vacation time. And then the judge says, what vacation time? And they're like, well, I don't know. Let me talk. And so then it goes on, and so that's important to have it clear and concise and say, Judge, graduation is June 6th. We want to have the custody to be here, and then it'll be transferred there. So be as clear and concise to make sure that the judge doesn't get angry with you. That helps, because if you start talking about these issues for the very first time in front of the bench and aren't prepared with answers, then the judge's patience sometimes run a little thin.
Yeah, and then just to interject, so we're in a state where, again, we can ask for all these things at order protection hearings, but a lot of the judges are, they're very short hearings. The judges might be uncomfortable getting into this level of detail with custody and visitation, would prefer them deal with that in an extended custody case. So I think what we're sort of trying to, when we're in front of a judge that's sort of skeptical or doesn't have time or doesn't want to get into it, really help it really narrowing down with your client that the reason why the judge needs to address whatever these important issues are is related to safety, because that is the source of conflict that is escalating whatever is going on in that family. So really, prioritizing and to make it clear to the judge, we've made the finding of abuse, the need for, to stop the abuse, but they're trying to tell you that this particular issue, whether it's custody or visitation or whatever, is the primary source of conflict between the couple, and that's what also needs to stop. So I think trying to bifurcate that and being more specific and making sure that that clients are able to effectively articulate why the judge needs to address that issue right now in this more limited hearing to reduce violence and reduce conflict.
And I
And
would
in a,
say that the more you can make that connection between stopping abuse and reducing contact related to custody and visitation and conflicts like that, are super important. I used to litigate most of my custody cases in the protection order proceeding because I wanted them to be decided in the context of the violence that was occurring. And so anyway, Judge, I'll kick it over to you.
yeah, and in a perfect world, which none of us live in, if you have a proposed order prepared that has that all in there, it just makes it easier for the judge because the judge is thinking, how am I going to write this all out? Or who's going to do that? And if you say, Judge, I have a proposed order that includes these issues. Now, if you don't have it, you don't have it, but that's really nice too. The quicker you can go through these cases for the judge's purpose, the better off it is. But it's really important to tie it to safety because that's the main concern of judges is the safety of the parties. And I think it's important when you have immigrant victims to always put in provisions that might deter parental kidnapping and tell the judge why you're doing that. And so make sure you put in there that they don't remove the child from the court's jurisdiction. Turn over passports if you're concerned about that. Make sure that you contact the consulate or have a statement asking them not to issue a visa or passport without an order. Now, I think the passport office is pretty good about that because when I went in to get my son's passport, they wouldn't let me do it unless my husband was there too, but you never know. So make sure you do that. And supervised visitation is important. And you can issue orders that can be used to remove children from international flights. And I think you actually did that, Leslie. You got a plane stopped before it took off and somebody taken off the plane.
It was Judge Rook in DC. It wasn't my case, but it was Judge Rook in DC. She was a master at that.
Yeah. Yeah. So don't think there aren't remedies to do that. But if that's a concern for you, make sure you write in as much of that ahead of time as possible because it's so much easier to prevent the kidnapping than it is to get the child back after the kidnapping.
So I'm going to jump to the economic remedies,
Okay.
trying to.
Okay.
And I'll just say, right, so let's quickly do a poll. I mean, check all that apply. Why are economic remedies particularly important for immigrant survivors? Looking. Good, we got about, make it to 60 almost, one more person. There we go. Okay, so Judge, 95% of people say it's because of the wait to work authorization. It's also because they can't purchase healthcare and in the exchanges, which is also correct. And immigrant victims have limited access to benefits. All of these are longer, and that the immigration cases are taking longer to process recently. Absolutely.
Yeah. Yeah. So it's important for your survivors that you consider economic relief in this area. And that's a hard issue for a lot of judges because they don't want sometimes to get into that. But child support, spousal support, if you have an affidavit of support, that's a very important document for you to get and to enforce. Those are great because in an affidavit of support, of course, the party has agreed to pay a certain amount, and that's a contract agreement that's separate from any kind of divorce thing. So, payment of medical bills and medicine, because you have a lot of kids with asthma that they need their inhalers and they have to have them. So that's important. Credit card debt. If a person is living in a home and they turn off the lights, they turn off the heat, they turn off the water bills, that's going to be a problem. So make sure you find out who is paying those bills now, how they're paid, and make sure it's ordered that those bills continue. Say the judge wants to refer it to divorce court, which is a common thing that happens. Judge says, work these out in divorce court. But until then, who's going to pay these bills? So you got to get it in there, even if they don't want to do it for a long time. Say, please enter an interim order that does this, and then, okay, we'll go to divorce court and try to figure this out if it does. So make sure economic relief is important in there, and make sure you say do not dissipate assets. That's really important because that happens all the time. All of a sudden, there's no money in any of the accounts, and trying to get it back is hard.
So Judge Collins, when you train judges, I mean, you mentored judges across the country as protection order judges. Did your training include these kind of immigration or economic relief remedies?
We do, but I can tell you there's a pushback from a lot of judges on doing these kinds of remedies. So you might have to, like Trish said earlier, you might have to focus on safety and welfare of the children as the reason for these things, and also certain things like cell phones. Judges are pretty good about requiring cell phones and things like that because that's the only way you can call for help. The days of a corded phone are over. So paying for a cell phone or repairing a cell phone that they break is important. So if you can't get all of these, focus on what is the most important and try to focus on that.
And we have for you just also some tax related remedies. You'll have these slides that you can use as checklists, but we're going to move on to the closing section where we're going to talk about the kinds of protection order remedies that help immigrant victims in terms of stopping immigration related abuse. And I'm very proud to say I didn't come up with this idea. There was a judge in DC in 1984 who I had a case before them. There was a lot of immigration related abuse, power and control happening. And the judge made this a part of their order, and judges in DC started doing it regularly. And we started training family lawyers in other parts of the country to get these kinds of orders as well. And it basically can order that it can order that the abuser not contact DHS, immigration officials, CPS, IRS, child welfare against the victim, absent a police emergency or a subpoena, and like a court order. And I can tell you, I have jailed at least 5 or 6 defendants in protection order cases for 6 months each for violating this provision. So using criminal contempt. It can be very effective. And it also, I did this back in the day. Some of you might have family-based victims who have family-based visa petitions that are worried that the perpetrator will withdraw the case. I've had perpetrators ordered in protection order court not to withdraw the immigration case. And again, it can be enforceable through contempt. And I've had abusers ordered to sign Freedom of Information Act requests in open court so the victim can get all of the information about the affidavit of support or anything else that might be in that immigration file.
Yeah, and I think, Leslie, another thing, we're seeing more and more of this happening. And then, of course, the time, it used to be that when an abuser did withdraw like a pending family-based petition, the timing on when that would take effect was longer, but we're seeing really quick turnaround. So if an abuser sends a withdrawal letter, we're seeing within weeks a denial of the applications. And so, that race to the mailbox is now also race to the courthouse. But also, we're also sort of seeing a lot of survivors not having access because there's electronic filing now, and the electronic don't have access to their own accounts with USCIS. So sort of really working on addressing access to
Right.
to any of the systems.
Account number, you can order the abuser not to change,
Passwords.
to
Correct.
turn it over in court,
Yeah.
all of that kind of stuff. And if
Yes.
you can't get in, you can show the judge it can't get in.
Correct. So just getting more creative about it as the technology changes.
What are some
yeah, go ahead. Yeah, so I think we're looking over, I think, for those of us, for someone like me who practices more immigration law, I'm really thinking strategically about, going into the order of protection hearing and turning over evidence and documents that may still be in the abuser's control. So just sort of wanted to talk about what some of those documents, if it's safe to bring up these issues in the order of protection hearing, because it is maybe one of your first and best and most rapid opportunities for the survivor who's had to leave quickly to get access to these things. So obviously Judge Collins already mentioned, we really want to make sure that that the survivor has control over their vital records. So all of the travel documents, passports, birth certificates, it's very hard to get those things if you don't have ID. To get new ID is an endless loop, and that's really important. Also, getting their cooperation to do that, but also, making sure that the abuser turns over copies of all immigration filings, receipt notices. Those types of things are important. And then, as Leslie, the slide here is that, if the survivor is going to move forward with filing, especially like, a VAWA self-petition or any other victim-based relief, they still have to prove their case. So they not only do they need access to their vital records and their immigration documents, but we are looking for helpful evidence of these factors on the slide, evidence that they married in good faith, children, those types of things. And this is a really amazing opportunity for partnership between the family court practitioner and the immigration law practitioner. In family court, the types of evidence or storytelling that you can do is somewhat limited, especially if, your state really focuses on physical harm versus non-physical harm. But as immigration lawyers will tell you, we can raise evidence of that entire relationship. So really working together to develop affidavits and use the discovery process or court orders. Obviously discovery process and order of protection doesn't make sense, but really thinking ahead about what you can get the court to order be turned over as a personal property or important documents is really important. So of course you have to weigh it a little bit, like you might be giving the abuser a clue that you're about to file a self-petition. So that's something you'll have to talk with your client about, how much you want to ask for in these hearings.
And we can provide technical assistance on it too, because what's important for you to understand, even if he gets a clue because of this kind of discovery, having this part of, not discovery, but having this turned over in a protection order case, that doesn't mean they can find out if she filed, find out what happened in the case, or get a copy of the case, because there's still VAWA confidentiality protections, which is a whole other training. So we're happy to provide technical assistance if you have concerns about those kinds of things. Judge Collins?
Yeah, and I'm going to kind of combine a couple of things here. So the remedies that will increase accountability and also best practices for drafting orders. So make sure the orders are clear and concise. Make them as detailed as possible. If you're asking for somebody to go to batters and the counseling and the judge orders it, ask the judge to set up a compliance call. Compliance calls are great. I'm a huge advocate of them. And that way the batter is held accountable, because you as a survivor have no way of knowing if that person actually is completing the batterer's counseling program, because they won't tell you. So if they have to go to court and show that they're doing it, then do it. Make sure that when you're issuing an order or asking a judge to issue an order, make sure that they include really detailed statements of the abuse. Make sure that they put in there about the physical and sexual assaults, put in what the relationship to the parties is, make sure you put in the relationship to the children, and include as many creative remedies as you can that will help the survivor.
Yeah, so we're coming up on the end of the hour. I do see that there have been some questions in the chat. We've posted some materials. Appreciate your participating today. Please do call us if you're working on a case, a protection order case, you want to think about creative remedies. You can call us for technical assistance. Tricia and myself and Susan Perlstein and Veronica Thronson all provide that TA. We also have access to judges like Judge Collins if you would like us, or we think we'd like to kind of check with the judge to make sure we're giving you the full range of advice on the particular issue you're calling us. Mark your calendar for the next Community of Practice call, which is April 28th. And please do take a few moments to fill out the survey, the evaluation survey for this session. Judge Collins and Tricia, thank you so much for preparing this, for bringing your wisdom to this session. And I hope you've all enjoyed the session, and don't hesitate to contact us if you'd like more information. We'll be distributing, we have lots of materials around creative use of protection orders chapters, bench cards and things and the like. I published the economic relief bench card that we have in the chat, but we'll make sure you have all of those as accompaniments to this session. Tricia, Rosemary, Judge Collins, any last comments?
No, just keep the faith, keep working hard, and make sure you can push the judges. It just because it hasn't happened before doesn't mean it won't be the custom and practice in a few years from now. But if you don't ask, it will never happen. So make sure you keep remembering that, and please look at the consequences of getting an order of protection against a survivor. It really can be very harmful. So don't let somebody push you into entering an agreed upon order on both sides, because that's not a good practice.
Right. Thank you,
Thank-
guys.
And
Thank you.
thank you, NCJFCJ, Christopher, for your support of this session. Bye-bye, everybody.
Bye.